everyone. Trying something new here. I'm Victoria, owner of Plan Forward Legal LLC. I run an estate and business planning firm. And I wanted to start today just by talking about Obergefell versus Hodges. That was a case that gave us a constitutional right to same-sex marriage. And I just wanted to talk a little bit about how it relates to the importance of estate planning. So I went ahead and just did a cursory Google of it and came up with a Supreme Court that had a lot of information about it. So I'm just going to read a little and then I'll kind of talk about why I find this to be really important. So the primary holding, which just means it's the primary decision that was made about the case, is that under the 14th Amendment of the U.S. Constitution, all states must recognize a marriage between two people of the same sex, and that such a marriage, if it was lawfully licensed and performed in another state. So prior to this, if you were married in New York and you moved to South Carolina, you didn't have to re-register your marriage in South Carolina. It was recognized along all 50 states. So it's important that they included that in there, that it wasn't just that states could perform it, but that it's recognized in all the 50 states. So here's why it was important. The facts of the case were in Ohio, John Arthur was suffering from the later stages of ALS. That's a terminal illness. I'm not going to try to attempt the scientific version. Recognizing the need to make critical end-of-life decisions, Arthur sought to have the Ohio registrar identify his partner, James Obergefell, as his surviving spouse on his death certificate, so that Obergefell could receive the benefits due to the spouse. Arthur and Obergefell had married in Maryland 2 years earlier. The registrar planned to certify Obergefell as Arthur's spouse on the death certificate, believing that discrimination against same-sex couples was unconstitutional. The state of Ohio prohibited same-sex marriage, however, and its attorney general's office mobilized to defend that ban. Also in Ohio, 4 same-sex couples brought a claim seeking the right to list both partners on the birth certificates of their children. In this case, known as Henry versus Wimslow, 3 of the couples lived in Ohio and all the children were born there. Henry v. Wimslow was heard before the same judge who reviewed the Obergefell case, who was District Judge Timothy Black. In Tennessee, 4 same-sex couples sued to force the state to recognize their marriages, which had been performed in California and New York. They argued that Tennessee's refusal to recognize same-sex marriage violated its own rule that a marriage validated where it is celebrated is valid everywhere. So here's why I'm interested in how I connect it with estate planning in several ways. One, this was set in 2015. So this is 10 years ago that same-sex couples were able to have their marriage recognized in all 50 states if that state was allowing a marriage license. So this case is now saying, the Supreme Court was now given the ruling that all states have to follow, giving same-sex marriage a license. It needs to be recognized in all 50 states. No one can prevent that. Here's why it connects to estate planning. Arthur, the first part that I had read, Arthur was in the late stage of a terminal illness. Arthur had a loving partner. That partner needs to be on the death certificate as the spouse. Why is that important? Because if Arthur had any type of Social Security benefit, or if Arthur had any type of military benefits or VA benefits, the fact that he was married allows that partner to receive the continuation of those benefits. Arthur and Obergefell were married in, I believe they said Maryland, and then they had to move to Ohio for whatever reason. So because he was going to die in Ohio and that a marriage wasn't recognized, it would cause an issue and the surviving spouse would not get any of the benefits. And that's not okay. So what are different ways that we can kind of avoid a situation like that? Now, when it comes to being labeled as a spouse on a death certificate, there's nothing really you can do in estate planning that will do that. But here's what we can build a case for is getting your will done, having a trust in place, getting your power of attorney documents, both for financial and health. So here's what I mean by that. Arthur can protect his partner from any discrimination if while Arthur is alive, he positions his partner as a financial and medical power of attorney. When you are dealing with finances and you get really ill and you're unable to handle your finances, your spouse, typically, if they are alive and able to do so, will help. However, if your spouse's name is not on the bank title, or excuse me, the title of the house, or on the um, title of your account on the bank, your spouse is very limited if can't do anything, essentially. So you need to label your spouse as power of attorney. So the bank recognizes, the state recognizes, creditors recognize that while you are sick and unwell and unable to do so, your spouse, your partner has the ability to deal with your finances. Anyone can be your power of attorney. It doesn't have to be your spouse. But if you're in a situation where you were unmarried, or like here was a situation where they were married in one state, but it was not recognized in another state, having the power of attorney financially filled out is really helpful. The same with medical, because Arthur was dealing with some really intense end of life decisions. He wants his spouse to make those decisions for him if he is unable to do so. That's what the medical power of attorney does. Depending on the state that you're in, I'm in Illinois. So the medical power of attorney does cover if you want to be let go if you're in a coma, or if you want to be held on for as long as possible, regardless of how much it is. Right? It does allow you to provide some personalized commentary on what you would want for end of life treatment. There's also a HIPAA form. So the HIPAA form allows you to designate someone to help moving your medical records, maybe particularly if you are elderly and you're in nursing homes, having to change nursing homes. So HIPAA covers that. And you want to make sure, what I always suggest is that whoever is your medical power of attorney should also be designated as your HIPAA agent as well. So again, anyone can be that. But in this situation, this is what's really important. And this is what can help your case to say, like, hey, I am this person's spouse, or I'm really important to this person. So even further on, when we had talked about birth certificates, so if you have a child and you are in a same-sex relationship and only one person's name is on the birth certificate, if something were to happen to that person, it does not automatically go to the spouse. Particularly if you aren't the father, right? Like you aren't the biological component of this child. Now, we can get into situations in which, it seems like sci-fi a little bit maybe, but they do have like mixed embryos, right? But the thing is, when you have a child and you're in a same-sex relationship, there are ways in which you can protect the child should the parent pass and leave the surviving spouse. That's through a will. That's through claiming guardianship, like who gets guardianship via a will. It can also be, again, reinforced through power of attorney documents as well to showcase that that partner is really the most important person in the room for the kid. So the reason why I'm choosing to kind of base this information in Obergefell is because we know that at the moment it is being challenged. So there is someone who is putting a case against that it's against their religious freedom in order to recognize this same-sex marriage. The Supreme Court that we're dealing with right now does tend to lean more, I don't want to say conservative values, but they do tend to lean more towards state rights versus federal. So what that means is that the Supreme Court is more apt to just leave it to the states more so than to uphold these amendments that we want, right? This was again only 10 years ago. I really don't believe that there was that drastic of a social shift um, that would warrant the rescinding of this type of decision. But here we are. So if you find yourself as someone who is married, you are married to a same-sex person, and you're feeling concerned about yourself and your family, what I would suggest is going ahead and getting this estate planning stuff in place. Because regardless of whether or not the state is going to recognize your marriage, it's going to recognize these power of attorney documents. It's going to recognize a will and a trust. So I would very much encourage you, if you're in Illinois, feel free to drop a line. I'll have my email attached to this video. If you live in a different state, you can still contact me. I have a vast network of attorneys that I can put you in touch with to make sure that you and your family are well taken care of. So thanks for, listening, and take care of yourself and stay educated.